Good morning. I'm Richard Aborn. I'm president of the Citizens Crime Commission, and I welcome you to yet another Milstein breakfast. We are absolutely delighted to have both Howard and the Chief Judge on what I consider to be an extremely important topic, and I'm going to do some introductions. But I first want to introduce the topic. The Chief Judge today is going to talk about bail reform. There's been an enormous amount, and I think growing understanding that we have probably overindulged a little bit on incarceration, not only in New York State, but throughout the country. And there's a pretty vigorous effort from both sides of the political spectrum, which is encouraging, to re-examine that and understand in I think, almost a more microscopic way where we should be using long sentences, and there is absolutely room for that and a need for that, and where we shouldn't be. That is, in a sense, the back end of the system. What has not received the same amount of vigorous attention, at least nationwide, it's starting to here in New York City and in New York State, is what happens on the front end. Under what conditions do we keep people before trial? What are the bail conditions that are the most appropriate for assuring someone's presence in court, and of course to also protect the community not currently part of the New York State statute? This is a critically important topic, and when you hear some of the data around this and some of the anecdotal stories which you'll hear about, you understand the immediacy of the need to take up this issue locally to the extent we can, certainly through OCA, through the Chief Judge's good offices to the extent they can, and I guess ultimately through the legislature, although one should not expect that to happen quite as rapidly. So it is one of these areas where each arm of government can have a direct impact on the activity going on in the courts. So to introduce the Chief Judge, it's my pleasure, as is always my pleasure, to introduce Howard Milstein, who is the host of this session, all of our sessions, and a longtime supporter of the Crime Commission. I'm looking around the room, and many of you have heard me introduce Howard. Some of you are new, and I welcome you. For those of you who have heard me introduce Howard before, I tell you it's always the same dilemma, which is he does so much. He always gives me material to work with, but it's really the quiet things he does, which I'm going to talk about in a second, that are in some ways most telling about Howard the person. You know, we used to have, in the age of technology, it's gone, but we used to have this sort of quaint notion that we had the lazy days of summer. Some of you are over 35 and you remember that. Well, you know those things are gone. I want to give you a sense of Howard's lazy days of summer. And I just happened to pick this up last night. I don't know if you even realize this. This is just, you know the old Kirk Weill song from May, December? The core of that song is from May to September. This is just from May till September. In May of this year, he picked up the Leadership Award from the New York Building Congress. In June, he was elected to the Board of Trustees of the National Committee on U.S.-China Relations. In July, he hosted, in fact he thought of and hosted, a commemoration of the 150th anniversary of the New York Fire Department. I don't know how many of you know about that, but this is the 150th anniversary. And he did it by inviting the leadership of the department, the Cardinal, and rededicating the kneeling fireman, which sits right outside of this building. As you exit this building, if you look to your hard right in front of American Bank, there's a very large and incredibly moving statue of a kneeling fireman, mourning, exhausted. Take time and read the two plaques that are up there. It's a very moving story about how that sculpture got here and what Howard did to make sure that all New Yorkers could see it and gave it a permanent home. We're only in July. In August, he launched a program with UC Davis around the New York Blood Center to continue his pioneering work in stem cell research, particularly to be used in a regenerative fashion for various organs. And then in September, a month later, announced an expansion of that, bringing in some very well-known international researchers and scholars to help with that effort. That's in addition to the thing I talked about last time, where he was running the New York State Thruway Authority and saved the state of New York $2 billion, that's with a B, that's real money, $2 billion in the rebuilding of the, well actually it's the building, it's a new Tappan Zee Bridge. And that's in addition to his day job. I don't know how you do all this. That's in addition to his day job as chairman of Emigrant Bank and running the Milstein Properties Group and all of their real estate. But it really is the quiet things about Howard that in some ways I really admire the most, because that's how you see a person's soul. You know, there's a very famous French philosopher, mid-19th century French philosopher, once said, the truest test of a person is how well they work without witnesses. And Howard works without witnesses all of the time. And I could go on for half an hour about the things that he has done for people that in some cases he's never met, people he knows well, that required his personal involvement, some money, but his personal involvement of time to help them in some incredibly difficult circumstances, some of which I know about very deeply and would bring tears to my eyes, and I suspect tears to yours. So it is for those many, many things, Howard, that we thank you not only for what you do for the Crime Commission, but what you do out throughout the city and frankly throughout the nation and increasingly throughout the world. Howard, thank you.
Wow, somebody's leaking my schedule here. Well, once again, you've surprised me. Given the longevity of our criminal justice policy forms, which you've stewarded so effectively, that's quite a feat. So, again, congratulations on finding out new stuff. By the way, there's some stuff you missed. I very much appreciate the honor of introducing today's guest speaker, a man of great vision and high ideals. Jonathan Lippman is Chief Judge of the State of New York and Chief Judge of the Court of Appeals. In a career that spanned nearly 4 decades, he's served on the bench since 1995. In the intervening years, he's held major court positions, culminating with his latest appointment as Chief Judge of the state in 2009. In his role as Chief Judge, Judge Lippman has taken on many of the most difficult issues plaguing our justice system, as he has done, and he's done so in new ways. This year's State of the Judiciary report is a case in point. And there's quite a list of initiatives that reflect new ideas to solve old problems. In an effort to create a more transparent system and increase public confidence, he's called for lifting the absolute ban on all disclosure of grand jury proceedings, especially in cases involving police-civilian encounters. As we all know, such cases have created serious issues of public trust all over the United States. Judge Lippman is also enhancing transparency of the legal profession itself. He set up a centralized database with lawyers' history of public discipline, if any. This database is easy for anyone to access on the Unified Court System's website. A simple click on the attorney directory on the court system homepage allows a user to search for a lawyer and find out what they need to know. He's called for legislation to implement civil Gideon. That means giving the same entitlement to legal representation for civil matters as we provide for criminal defendants, especially when it comes to the basic needs of life. This would be the first statement of its kind in our country to come from a legislative body. Judge Lippman launched a pro bono scholars program that allows law students to sit for the bar exam in February of their 3rd year. This in exchange for devoting their last semester of law school to full-time pro bono work. He then added a pro bono fellows program that provides funding for law graduates in public interest positions. The judge created a navigators program of non-lawyers to shepherd those in need through the litigation process. He's pressed for mandatory e-filing in the Supreme Courts in all New York counties for all classes of cases. This is expected to save New Yorkers more than $300 million annually. Over 10 years, that's even more than $2 billion. And importantly, it will help bring the courts into the 21st century. Judge Lippman is reforming the fiduciary appointment process, a system that has long been beset with charges of nepotism and cronyism. Finally, he has set out to put New York in the forefront of fighting sex trafficking. In less than a week, he'll be hosting a national summit on human trafficking and the state courts. So his visit with us today, with his new idea, is quite timely. Judge Lippman has taken on the status quo. He believes that access to justice is the defining principle of our court system. His mantra is, our society will and should be judged by how we treat the most vulnerable among us. To that end, he has dedicated himself to making the court system open to all who turn to it. course, I can relate to all this, having the privilege of being married to a lawyer who happens to serve on the board of Judge Lippman's Pro Bono Fellows Program. Beyond that, my wife Abby chairs the New York Legal Assistance Group, working with those in need before they get to the courts. But the idea of open access is the same. Another reason why I'm so proud to be hosting our Chief Judge today. Your Honor, please come to the podium.
First of all, let me say how delighted I am to be again at the Milstein Policy Forum. I know that Howard and Abby remember that the last speech I gave at this forum was on the human trafficking initiative in New York, and now I think the entire country is focused on this real evil of modern society, and we are thrilled to have chief judges from around the country come in within the next week to focus on that issue. And I want to say in particular to Howard and Abby that thank you for all the good deeds in so many areas. I am so energized when I see the things that the two of you do. It's hard to keep up, let me tell you. But good deeds are contagious, and I think we all have to do absolutely as much as we can to make this a better city, a better state, and a better country. So thank you, Howard, and thank you, Abby, and thank you, Howard, for sponsoring this event. And of course, I want to thank Richard Aborn, who, for his leadership of the Citizens Crime Commission, for his kindness to me over many years. It is just an absolute delight and pleasure to work with Richard. He believes in being creative and innovative and new ideas. And as Howard says, fighting crime is not exactly a new problem, but how we do it in a thoughtful, smart, creative way is really what it's all about. And Richard, you certainly lead the way in that regard, as does the commission. And I thank you for having me again here with all these committed people from so many parts of the New York City fabric of life. So thank you, Richard. Okay. Today we're going to talk about bail, as Richard indicated, and let me start with this. If you are familiar with Alice's Adventures in Wonderland by Lewis Carroll, you may recall the phrase, sentence first, verdict afterwards. These words invoke a nonsense, topsy-turvy world of absurd illogic, a world where it is acceptable to mete out punishment before trial. They are meant as a parody of justice, yet the words ring true for New York's bail system. Today, defendants who are unable to post bail serve a sentence before their cases are ever resolved. They do so regardless of innocence or guilt. And the harm that this injustice causes is intolerable. The story of Khalif Browder, familiar to many of you, is an especially wrenching example. He was arrested in the Bronx at age 16, accused of robbing a backpack. He never wavered in maintaining his innocence. He declined all offers of a guilty plea, but unable to make bail, set at $3,000. Khalif was sent to Rikers Island for over 1,000 days. After 3 years, prosecutors finally dismissed the charges. They were unable to produce their only witness, who had left the country. In the meantime, Rikers was a horrific experience for Khalif, one that included violence and abuse at the hands of guards and other inmates, extended periods of solitary confinement, and attempted suicide. When he was released from prison, He had difficulty recovering from those experiences and from the loss of his adolescence. This past June, Khalif Browder committed suicide. 2 years after his release, he committed suicide. These heartbreaking and deeply frustrating events exemplify much of what is wrong with our criminal justice system in New York. Khalif Browder was still a child when he was arrested, and he should not have been treated as an adult in the criminal justice system. Yet New York's criminal laws continue to treat 16 and 17-year-olds as adults. As you know, no other state in the country, with the exception of North Carolina, sets the age of criminal responsibility this low. It continues to be absolutely mind-boggling, with all we know about adolescent brain development, that our laws in New York have not yet been changed. Furthermore, this seemingly straightforward robbery case should never have taken 3 years to resolve. The delays were simply unacceptable. We have taken steps to address these two problems. We have proposed comprehensive legislation to raise New York's age of criminal responsibility to 18, and we continue to await action on that proposal. And we are working closely with prosecutors, the defense bar, and the mayor's office to attack backlogs and address delays in the adjudication of cases in which defendants are in custody. But today, I want to address the third problem that the Browder tragedy starkly illustrated: our unsafe, unfair bail system. 2 years ago, I proposed legislation to fundamentally reform our system of bail. And since then, I have talked day and night about this issue. When a defendant is charged with a serious offense, the legislation would require judges, when making a bail determination, to consider whether the defendant poses a risk to the safety of any person or community. Unlike 46 other states and the District of Columbia, New York does not require or even permit judges to take public safety or the dangerousness of the defendant into account. How absolutely strange. Studies show that evidence-based risk assessment instruments can accurately distinguish between low, moderate, and high-risk defendants at the pretrial stage. The risk of reoffense on release, when appropriately balanced with the presumption of innocence and an opportunity to contest the underlying considerations of the risk assessment instrument, must be part of the bail determination. It defies common sense that judges must ignore the safety of victims and communities when setting bail. The proposed legislation would also create a statutory presumption of release without bail, where the judge concludes that the defendant poses no risk to public safety or legitimate risk of failure to return to court. It also makes clear that judges are authorized to impose conditions on a defendant's pretrial release, such as participation in drug treatment or a supervised release program. A statutory presumption of release, as provided for in the proposed legislation, is critically needed. Bail in New York is intended to ensure a defendant's return to court. Instead, what it does is set up a two-tiered system of justice, one for those with money and one for those without. The numbers are alarming. Each year in New York City, nearly 50,000 defendants are jailed because they cannot make bail. Defendants are detained at arraignment in 1/4 of all non-felony cases and 60% of felony cases. Nearly 90% of those for whom bail is imposed do not make bail at arraignment, and over half of those defendants remain in jail for the entire duration of their case, from arraignment to disposition, without ever being released. Fully 40% of the city's jail population is made up of pretrial detainees who are in custody simply because they are unable to post bail. These numbers do not lie. Far too many people are trapped in pretrial detention simply because they are poor. The consequences of unnecessary pretrial detention are deeply corrosive. Pretrial detention can tear apart the very fabric of people's lives. Being incarcerated for even a week can mean loss of income, loss of employment, and loss of public assistance. A person in a low-wage, blue-collar job may well be fired if he does not show up for work for a few days. Lack of steady wages, even for a matter of days, can cause people to fall behind on their rent and face eviction. For defendants who care for children or aging relatives, pretrial detention impacts their dependents as well as themselves. Children can end up in foster care. The elderly may end up hungry or uncared for. Defendants and their families may lose their public housing or shelter beds. Those still in school lose days or weeks of their education. And let us not forget that pretrial detention can have health consequences with exposure to violence and disease in the tight quarters of a city jail. Lives that may be precarious to begin with can fall apart, creating an avalanche of social ills. It is critical that bail not be needlessly imposed and that it not be needlessly high when it must be imposed. But despite the clear need for reform and the recent public attention to the injustices of the current bail system, the legislation has languished as our policymakers are paralyzed by tough on crime, soft on crime, finger pointing. The need for reform by any standard is stronger than ever. We cannot wait to act for 1 second longer. And as the steward of the judiciary, I will not wait to act when it is within my ability to do so. Accordingly, I am announcing today a series of reforms that the courts can undertake immediately, steps that we can and will take within the constraints of existing law. These reforms will ensure that the judiciary is doing everything it can to limit the great damage and human costs that result from excessive pretrial detention. Don't get me wrong. There are cases, and many of them, where pretrial detention is warranted and the public safety is threatened. And judges must have the discretion to make independent bail determinations according to their judgment under the statute. The reality is that day in and day out, judges are held to account for the decisions they make by the media, by victims, by elected officials, by the public, and most of all by themselves. The reforms I announced today are undertaken with full consideration of the very real pressures judges confront, the somber responsibility they bear, and the difficult job they do. The first of these reforms is a system of automatic judicial review of bail in each and every case. Over 80% of defendants for whom bail is imposed have bail set at less than $5,000. In misdemeanor cases, 95% have bail set at less than $2,500. But for far too many defendants, bail of $2,500 might as well be $25 million. Defendants who are struggling financially far too often are not able to post even a low bail amount or secure a bail bond. In fact, a bail bond may not even be available. Experience has shown us that bail bond companies, profit-making entities, generally are unwilling to write bonds for amounts less than $1,000 because they are not sufficiently lucrative, even with burdensome, non-refundable fees and collateral requirements. Of course, it is not uncommon for bail to be set at $1,000 or more, even for relatively minor, nonviolent offenses. Indeed, the median bail amount in misdemeanor cases in New York City is $1,000, and bail may vary significantly for similar defendants with similar charges. At the same time, and this is critically important, research shows that the defendant's likelihood of returning to court after release on bail is barely affected by the amount of bail set, if at all. According to studies by the New York City Criminal Justice Agency, defendants out on bail in the $50 to $500 range have a 12% rate of failure to return to court. And those whose bail is between $500 and $1,000 and between $1,000 to $5,000 have an 11% failure to return rate. If the goal is to release defendants with the assurance that they will return to court, the amount of bail does not seem to matter much or at all. In order to ensure that bail is fair and that defendants do not remain locked up unnecessarily, we are now implementing a judicial bail review program throughout New York City Criminal Court for all misdemeanor cases. The automatic review will be triggered whenever the defendant has been unable to make bail. The review will be conducted de novo, as already authorized by New York's criminal procedure law, by a single judge in each borough. This means that the judge will take a fresh look at the case and make an independent determination whether the bail amount should be adjusted higher or lower, or whether bail should be permitted in a less onerous form. In contrast to the arraignment parts, where enormous case volume and legally imposed time constraints often preclude a more thorough consideration of relevant factors, and where information about the defendant's circumstances may be limited, this process will give the reviewing judge a fuller opportunity to make a more considered bail determination, and defense counsel the time to present a more accurate picture of the defendant that will be relevant to that determination. With more information available, and with one judge in each county conducting the reviews, this new process will also lead to greater consistency in bail decisions in misdemeanor cases. As for felony cases, we will be issuing new court rules requiring regular, periodic judicial review of case viability and bail. When felony defendants are in custody, pending disposition of the charges against them, the rules will require, the new rules, a status conference at designated milestones in the case. At the status conferences, the judge will evaluate the continuing viability of the prosecution's case and readiness for trial, and where appropriate, make modifications of the defendant's bail status. For example, the judge may inquire of the prosecution when they were last in contact with their key witnesses, or if the parties state that they're not ready for trial, the judge would require an explanation of why that is so. In the Khalif Browder case, there were numerous adjournments, one after the other. It was not until 3 years into the case that a judge, after pressing the prosecutor and proactively seeking to resolve the case, learned that the prosecution had lost contact with its key witness. That in turn finally led to a resolution of the case, a dismissal. By institutionalizing this structure for regular review of the viability of a case and, where necessary, review of bail, the courts will be able to better ensure that felony defendants do not languish in pretrial detention. The third initiative I announced today is a pilot electronic supervision program in Manhattan Criminal Court. Electronic supervision can be a valuable option for judges, giving them the additional security they may prefer in appropriate cases that defendants will return to court without having to post bail. Other states and the federal courts began using pretrial electronic supervision over 20 years ago. And District Attorney Cyrus Vance will soon be spearheading an electronic supervision pilot for 16 and 17-year-old defendants in Manhattan. So it is time that we take greater advantage of modern technology that can electronically track defendants while they are on pretrial release and quickly identify where they are if they fail to appear in court when required. This fall, working with Herb Sturz, Herb, raise your hand, a nationally recognized pioneer in criminal justice reform, Manhattan judges will be able to release defendants charged with misdemeanor offenses on electronic supervision while they await adjudication. Domestic violence, assault, and sex offense cases will not be eligible. Defendants will be considered for electronic supervision at their first court appearance after arraignment if they remain incarcerated, ensuring that it will be used only for defendants who are unable to make bail. They will also receive robo-telephone calls and texts reminding them of their court appearances. Apart from the benefits of those who would otherwise be detained, electronic monitoring will save huge amounts of money for taxpayers. The annual cost of detention in New York City is over $100,000, drastically more than the modest costs of electronic supervision, pennies by comparison. And the economics of unnecessary, excessive incarceration are the same throughout the country. And that is why conservative and liberal states and smart on crime political leaders in jurisdictions around the country have joined forces to support programs like electronic supervision and, more broadly, to end America's dubious claim to being the world's leader in imprisoning more of its own citizens than any other nation. This is not a right-left issue, but one of purely of sound, reasoned, humane, and economically prudent criminal justice policy. Finally, we will work with judges to increase the use of less onerous types of bail that are currently authorized under New York's bail statute, but are rarely, if ever, used. New York's bail statute provides for 7 types of bail bonds, as well as cash bail and credit card bail. In practice, however, judges exclusively use only 2 types: cash bail or insurance company bail bonds. Given the crushing volume of cases in the arraignment parts and the overwhelming time pressures they face there, it is understandable that judges resort to those 2 familiar, traditionally used types of bail. But we need to make much better use of every available option that will allow those who are presumed innocent to more readily post bail. Just one example of a form of bail authorized by law but rarely used is a partially secured bail bond. This is similar to the commonly used insurance company bail bond in which the defendant posts a small percentage of the bail amount in cash, usually 10%, and then signs a bond for the remainder with the bail bondsman. A partially secured bail bond works the same way, except that rather than signing a bond with a bail bondsman who may charge a significant fee, or who may not even issue a bond because it would be unprofitable, the defendant signs the bond for no fee directly with the court. So rather than requiring $1,000 cash bail or an insurance company bond, the judge can set bail at $1,000 with a requirement that a much smaller amount, say $100, be paid up front and the remainder in the form of a partially secured bond filed with the court. This will allow a defendant of modest means who may be unable to secure an insurance company bail bond to be released pending disposition of the case. To encourage and facilitate wider use of these forms of bail, we will be enhancing training for judges and clerks on the availability of alternative types of bail and the procedures required. We will also share with them the extensive research that documents the efficacy of alternative forms of bail and varied bail amounts in ensuring return to court. The criminal court judges who will be sitting in the new bail review parts we are creating will be ideally suited to make greater use of these legally available options. Other jurisdictions and other states use alternatives to cash bail, from DC to Arizona and in between. And there is absolutely no reason why New York should not be a leader in this same regard. Make no mistake, in my view, the ultimate goal may well be to end our reliance on cash bail in New York. It is wrong. It is wrong, to put it simply. It is fundamentally unfair for a person's liberty to be all about how much money you have. By any standard, it is wrong, and money should be removed from the equation. I should also note that the courts are not alone in recognizing the need for bail reform. In an effort to reduce the jail population at Rikers Island and to inject more fairness into the process, the mayor's office and the city council are setting up a $1 million nonprofit bail fund to assist low-income defendants in posting bail. The mayor's office is combining this effort with an expansion of supervised release programs, building on the small but successful programs in Queens, Manhattan, and Brooklyn. We all recognize that a bail system that punishes people before they are convicted and that punishes people for being poor is inconsistent with basic principles of justice. Again, public officials and politicians of all stripes are now acknowledging that we face a crisis in mass incarceration in this country. Not only do we imprison large swaths of the population, but a grossly disproportionate number from minority communities. Clearly, many in our jails and prisons have committed serious crimes, and it is critical that our justice system responds swiftly and strongly in those cases. But what of the many who present no risk to public safety, who have been accused but have not been convicted of anything? How can we maintain the presumption of innocence guaranteed by our Constitution when so many people charged with low-level offenses are held in jail before trial simply because they lack the means to post bail? It is wholly unacceptable to allow the current system to continue when we have many tools for change within our grasp. While we wait for the legislature to act, and we have already waited far, far too long, The court system cannot and will not stand idly by. By taking the series of steps I have outlined this morning, we can dramatically improve the quality of justice in New York right now. It is my hope that with the reforms I announced today, we can make major strides in overhauling our broken system of bail and bringing about much needed change in New York. As I've noted, all the things I'm announcing today can be accomplished within existing law. What we can't do alone, however, is to make public safety a part of judicial determinations on bail or change the present statutory scheme that places people of limited economic means at such a serious disadvantage. Nevertheless, without jeopardizing public safety, these reforms will make the abstract, intangible concept we call justice more concrete and real for New Yorkers who are poor or of limited means, and more often than not are from minority communities whose confidence in the justice system is at low ebb around the country. New York should be the last place where that is the case. Reforming the institution of bail in New York from this day forward will go a long way in ensuring that our justice system not only protects the public safety, but also is fair and just for each and every New Yorker, no matter their station in life or the amount of money in their pockets. Thank you so much.
Judge, thank you very much. The Chief Judge, as always, has been gracious in agreeing to take some questions. If I may, can we have our invited guests go first, and then we'll invite the press to ask questions. Cy?
Thank you, Richard. First, Judge, let me just say, as you approach your last months in the job, what a remarkable job I think, and I think we all think you have done, and the vision that you have tried to bring in the criminal justice system to make us both safer and fair, and I applaud you. And I thank you.
Thank you, sir.
I fully support your proposals, but I wish to make a point as to how certain things that I think need to be addressed in order to make it a success. First and foremost, I think I speak for everyone in the criminal justice system, where we need to find a way that empowers judges at the state level to pick a trial date, a firm trial date, that the parties have to adhere to. And I empathize with the judges who are juggling many schedules of lawyers, but if you wish to move cases forward expeditiously, as you do, first and foremost, we have to have a system that actually gets cases out to trial and minimizes the amount of time defendants may be in trial, even if their attorney is working hard on that case or others, number one. Number two, I think that we need to make sure that your vision of appropriate bail amounts is set. We welcome that, and we will support you, but we do need your help in getting the amount of judges to organize the attorney schedules, and secondly, to make sure that we have enough judges. Because in our county, at least, despite, and with your efforts, you can't get cases to move to resolution without adequate numbers of judges to try those cases. So I hope that will be something you will also consider as you implement your vision for the future of OCA, and I thank you.
Thank you, and sorry, I wholeheartedly agree. The key to the whole criminal process is having firm trial dates and keeping to those dates. And absolutely, we need the resources to get it done. And I think we need more judges. And it's fair to say that we were thrilled that we were able to get a package of family court judges. And going back to the days, Si, as you know, and you and I have talked about this, Bob Morgenthau, we've been pushing for more criminal judges in the city and in the state for that matter for many years, and it's long overdue, and I couldn't agree with you more.
Anyone else?
You? Another Morgenthau acolyte.
And questions are not restricted to this table. Anybody can answer.
Chief Justice Lippman, I have a question, or not a question, I have a suggestion. I think that as part of your bail reform package, all right, that is kind of emanating from the OCA, I think the one area that you should also touch upon is the frequent request for bail source hearing. And that has been abused by the various district attorneys in the city, in the sense that there is no standard. Right? When the bail is set, the assistant frequently demand a bail source hearing, which resulted in further delay in the release of the defendant, and frequently also is used as a device for the district attorney to look into the financial sources, background, and is almost like akin to an investigation. So I believe that that's an area that should be touched upon in your bail reform package. And another issue that I believe that DA Vance has touched upon is the delay. What I have witnessed over the years is that 3030 has been abused in the sense that the district attorney used 3030 and with the court's cooperation to delay a case going to trial in the way how adjournments are treated as exempt from the 3030 calculation. And when obviously that causes a backup.
Well, look, my belief is that there's enough blame to go around in the criminal justice system between prosecutor, defense, the judiciary. We have to prevent delays. Look, the tragedies that come, that make these issues real, come because we don't move quickly enough. And I think the whole criminal justice system, all the players, and we've done this in so many ways with all of our friends in the district attorney offices, in the defense, from the defense community, and the judiciary, police, law enforcement, we all have to work together to eliminate delays. And I agree that delays only create havoc and injustice and sometimes tragedy. So we take your suggestions to heart, and we certainly are working on that, and we'll continue to work with our partners on cutting down as much as human possible delays in the criminal justice system.
3030 for you non-practitioners in the room is the state equivalent of the constitutional right to a speedy trial. It's how courts decide whether or not delays have been too long.
I think were you bidding? You were not. Okay, sorry. Anyone else? Yeah, could you state your name?
Hi, Judge. Zach Bain from New York 1. I had a question. I think most advocates would applaud what you've advocated here and proposed, and I think that it's a great first step. But some of the larger reforms you're talking about, I think you'd agree would have to be done legislatively. And what we learned this year in Albany is that there really wasn't much of an appetite for that. He said in some respects, 16 and 17-year-olds, for example, being tried as adults, it's not really a right-left divide, but that seemed to be precisely what it was. At least that was the holdup. So I just want to ask you in terms of the larger context, would you urge the governor and some of the benefactors here in New York to support a Democratic Senate so that some of these reforms could actually get enacted? How important is that, and how essential is that to enacting larger reforms?
We don't support Democratic or Republican senators. But what I will say, the issue that you raise is certainly a valid one, that criminal justice reform is not for the short-winded. And it is a very difficult, politically charged issue. And you know, it's a cliche, but it's true. We don't care about being hard on crime, soft on the crime. We care about being smart on crime. And absolutely, I believe that there is momentum for fundamental criminal justice reform in all of the areas that you mentioned and so many others. And I think you're going to see, and I know this is a rarity to express confidence in our friends in Albany, that you're going to see the policy-making branches of government in the coming year and years do fundamental reform in criminal justice. The momentum is there, and the pity is that sometimes it takes a tragedy to put a human face on a criminal justice issue. And, you know, that's what's happening. I think there's a lot of momentum. There's reform in the air on so many regards. You take what I mentioned about the Browder case. There's a case with 3 things that are wrong with the criminal justice system jump out at you. 1, the juvenile justice laws, and absolutely that is going to be changed, and soon. 2, the delay in the trial process, which has been talked about, and 3, bail. That a kid who gets accused of stealing a backpack is in jail for how many years for not being able to make bail of $3,000. So we don't support either side, Democrats or Republicans, but what we do support is smart on crime, executive, legislature that understands the critical importance in a nation and a state that has been rocked with so many instances where many communities do not have confidence in the justice system, and that is the one thing that undermines us more than anything else, is if people lack confidence in what the justice system is designed to do. So we need reform, we need smart reform, we need all the players, Democrats, Republicans, prosecutors, defense, judges, everyone joining together, because we need in many areas, whether it be juvenile justice, bail, wrongful convictions, a grand jury, they all need our attention, and we need it now. And what we're doing today is saying that sometimes when you knock your head against the wall over and over and over again, seeking legislation, and the process takes, to be kind, a little longer than we'd like it to, you have to be creative and innovative within the bounds of existing law to right injustice and to make sure that the justice system, to the maximum that we can, meets its lofty goals. And that's what we're trying to do.
Thank you. Rory Johnston, I chair the Committee on Courts, Legal Services, and City Council. And I just want to say, Judge, how much we appreciate your vision and your thoughtfulness. But in light of the question that was just asked of you,
That's why you escaped from Albany, right, Councilman?
there's a reason I'm not getting on that way.
God, I'm only kidding.
But just to emphasize how important it is, as you're demonstrating, for each of the branches of government, or whatever level of government, whatever legislative body or your district attorney, that there are things that can be done within the power that already exists. And I think the brilliance of this proposal is that as much as it might hope to prod Albany or other actors on the stage into action, there is enormous authority within the existing statute, within the existing structure, and your willingness to find that authority and to use it, hopefully as a role model for everybody else in the system, and we don't continue to point fingers elsewhere and say, if only they would act, if they would act. We all have OCA, council, district attorneys, et cetera, et cetera. There are things that each of us can be doing to improve parts of the criminal justice system. And that, above everything else, that one could say about your tenure as chief judge, which is terrific and really visionary. I think that's the lesson that hopefully people take away from this morning and go back in their own fields and realms, and roll up their sleeves and do what they can do today.
Thank you, Councilman. I greatly appreciate it. Thank you so much.
So before we wrap up, I do need to expand on what both Rory and Cy have started to say. This is likely your last appearance with us as Chief Judge.
You never know.
Much to my regret. I said likely, not definitely. And I have to say, actually, I'd like to amplify a word that Cy used. When the Chief Judge Kay left, people said, tough act to follow. You have really followed that act and really taken it to a new high level. And Cy employed the word remarkable. And I'd like to think about that word for 1 second. Remarkable is to constantly leave a mark, to remark. And I think one of the strengths of leadership and the tests of leadership is not as much what you do while you're in office, but what stays permanently after you have left. And you have left a huge series of marks on this system. They will reap dividends for years, and we are deeply grateful for your leadership. Thank you so much. Thank you all. This has been a fascinating discussion. We will see you at our next event. Thank you.